Yo, One Life family, what's going on? How everybody feeling? Good morning, good morning, good morning to everybody. I hope everybody is off to a great start today. Ladies and gentlemen, today we're gonna be talking about some things, man, because I've been up doing some research all night, man, researching and reading and listening to some things that's been going on that kind of explains a political side, a backstory to the stuff that's going on with Fulton County. Good morning, Tandra. And of course today we're going to be finding out if SB Shannon Stillwell can get his charges handled. It's a big day down in Fulton County Courthouse, man. So we're just gonna be tuned in, talking about it, kind of see how the things play out, seeing if Yak got to get a bond, seeing if Shannon Stillwell gets his plea worked out, as well as seeing about the remaining defendants in the YSL case, seeing if they are going to take a plea or if they're going to be going to trial, and all that is stuff that's coming up today, starting at I think the court starts at 9 o'clock. Okay, so a lot of y'all hear me talking about Fani Willis and talking about the jail and the conditions and stuff like that, and now they've got these whistleblowers, okay, and it's crazy because these whistleblowers, they're everywhere, okay, and one of the things that Fani Willis said that when she came in the office was, and I want y'all to know this, I like Fani Willis. I don't really let other people kind of determine how but I like Fani Willis, so I'm non-biased. You know what I'm saying? I don't dislike her, and I'm not a fan of her type situation. But I do know that her thing coming in the office was to hit these people with RICOs, and I think she just started slapping RICOs on everybody. And people better be careful because Atlanta was the first ones to put a RICO on dirt. Just like they came back and then they Fani Willis put that RICO on YFN, YSL. It's a couple more people out there that got hit with RICOs and more RICOs to come. Now, this is very important about these whistleblowers that's coming out, and they're talking. This lady, Trevian dang, what's her last name? Trevian somebody. I forgot her name. Hold on. This stuff is really deep, y'all. It's deep. It's deep. Hold on. Cuddy. Okay. And it's crazy because she has a connection to the lady that's the whistleblower who I'm finna get into all this information. And this is all pertaining back to Fulton County and these RICOs. And they saying that these people that's involved in these RICOs is like high up people. And the lady done blew the whistle saying that Fani Willis, Armstrong Williams, what's going on, Culture News, what's going on, everybody? And dude Bill Barr was the attorney general, you know what I'm saying? I think he was the attorney general and worked with Donald Trump. And so what's going on, Evan? And work with Donald Trump. Now they saying that the lady who whistleblower, and I'm finna play it for y'all. Bill Barr, Armstrong Williams, and all this is allegedly, but she got her receipts and stuff like that. But I'm just saying because these people are in a frenzy, and they saying that this stuff is getting ready to come out, and it's gonna show a lot. It's gonna expose a lot of the political aspect and why Fani Willis is doing these RICOs. Now they saying that and it's crazy too because one of the dudes I had a chance on going on Judge Joe Brown and Dana's show and talking about Fulton County, and they had a lot of people come on there from Judge McAfee to Harrison Floyd to Trevian, to a lot of people, you know what I'm saying? And one of my things was bringing awareness to Fulton County. Misha Maynard was on there. There was a lot of people that was on there, and I was listening to the politics and I was learning the political aspect and seeing how they just as dirty as the streets. You feel me? But the whole point, what I'm getting at is this is back when Fani Willis locked up 18 co-defendants. I think 18 of them, Trump and 18 co-defendants. And a lot of people got a chance to interact with each other. So when I seen her on the show, I'm finna play for y'all, Trivia, doing the interview, I was like, dang, that's the girl from for a thing. So I started researching, going down the rabbit hole, and I'm finna play for y'all this stuff. And I kind of want to just show y'all what's going on with the back end, why it's so important, and why Fani Willis is going after these Ricos so hard. You feel me? But look, let's get into it, y'all. And now listen, I'm not gonna lie to y'all. From what the whistleblower number is saying, and I didn't sit here ever since yesterday, all night, all the morning. I've been watching, listening, researching. They're saying that they got, okay, so this is what she said. They got so much evidence on Fani Willis. Fani Willis was supposed to have a court date December the 5th, and it was a hearing that they were supposed to have. The lady said that Fani Willis went and worked out something with the court system. I forgot what she said she went and worked it out with, because they got information that will end Fani Willis' career permanently. And she definitely will probably be in jail. Now, I'm going to let y'all hear what the whistleblower is saying, and y'all can kind of hear it for yourselves, because the first interview that the lady did came out the other day, but over last night while I was up watching this stuff, he released another video where he talked to Armstrong Williams, and he talked to the whistleblower directly. Man, this stuff is deep. And they saying that they getting ready to have this stuff come out, and it's going to goddamn, man, they saying it's going to cost some stuff now. These folks, man, listen to these people, y'all. Y'all listen to them. Check this out.
What you want? Like, sit the fuck down.
How are you involved in this RICO case? Why are you a co-defendant? Just briefly, and then we're going to get into the crux of the matter.
Sure. So I actually was charged with attempting to influence a witness. And you know, I went to see a woman in Georgia who I was told needed help, and you know, with the whole farce and everything that's gone on behind Trump these last, you know, well, I'm going to say it's been happening since 2015, but it got really dirty in 2020, and I ended up being his co-defendant by attempting to help a woman in Georgia who truly needed it and asked me for it.
Are you able to divulge who that woman was?
Well, let's put it this way. It's the one.
The average person sees around 10,000 online ads daily. Here's how a man's life would change if he used pot.
Woman who was an election worker in Georgia. I was found on body cam interviewing this woman who agreed to meet me and talk. So I think that's probably all I can divulge about that. But it's very public.
And I love this.
Number one trending story on December 10th. Reuters wrote the story, and it was the number one trending story in the world, December 10th, 2021. So I'm pretty sure everybody knows about, or can know about. It's very public. The reason why I'm indicted with President Trump.
And I like and there's 18 other co-defendants, and it's interesting that it's the very last case amongst the federal RICO cases. You know, Jack Smith case got dismissed. Don Juan Mershon, I call him Don Juan, fake Don Juan Mershon. You know that. You've been watching the show. And
I've got some information on that coming up later.
Hello, we got another exclusive. I love this. And it's interesting. And then the appellate courts just canceled oral arguments, which I know you're going to talk about and tell us a little bit about that. But here's what I wanted to say really quickly, and then the floor is yours. It's so funny because you know exactly how to navigate what is the legalese and the legal sort of hurdles, if you will, on what you're able to disclose and what you're not. Whereas other guests I have, they don't know how to do that. So we're really, really happy to have your wisdom, experience, and judiciousness in this on this show. So, okay, so you were indicted for that. You were included as one of the co-defendants. You have the famous headshot, which I think is classic. So tell us a little bit about why are we here today? Talk to us about what you have discovered and what you're able to share to the fullest extent with our audience.
So in the instance that we're talking today, I was approached by a whistleblower who happened to be present in meetings with Fani Willis. And these meetings happened in Washington, D.C., in the office of Armstrong Williams. You may know Armstrong Williams as this media personality, and his media company is under the umbrella of Sinclair Media and David Smith. Armstrong Williams brought Fani Willis to his office multiple times. There are recorded communications and notes within the meetings that Fani Willis was in the office of Armstrong Williams with Bill Barr.
Wow.
Bill Barr, which it sounds crazy that we're talking about Bill Barr in a Fani Willis RICO. Bill Barr was outed by the whistleblower as being the architect of Fani Willis's Fulton County RICO.
Wow.
Bill Barr.
This is former Attorney General, former Trump, Big Bill Barr. Yeah, Big Bill Barr. I'll bring up a picture.
This is deep.
Yeah, that would not investigate the fraud in the 2020 election. And now, per this whistleblower, we know why.
Wow. And I'm going to share some clips too from this amazing post that you created, right? You created that, right, Trevian? Yeah. Yes. That I'm going to share some clips from that where you have so tell us a little bit about so you have the PR firm, correct? You have the media firm?
Howard Stirk Holdings. It's a fictitious company.
Oh, wow.
Run by Armstrong Williams. And they do a lot under this company. A lot of very illegal things per this whistleblower in this company. And we can talk about that later too.
Wow. Wow. So how did Bill Barr get included in this? What was the tipping point that this whistleblower was able to identify Bill Barr as somebody who was one of the architects? Was he the architect, or were there more?
She was in the meeting with Bill Barr and Fani Willis working in Armstrong Williams's office. All of this happened in Armstrong Williams's office.
Right.
She talked to Fani Willis before. She's mailed classified documents to Fani Willis's personal home address, which we know has been confirmed as her address. She has witnessed the collusion between Fani Willis and Facebook to put hits out on me in Armstrong Williams's office. I have the name of the person at Facebook. We have seen so much. This whistleblower is from a political family in Brazil. Mm-hmm. She's a journalist. So it's her nature to take notes, to record, to take photos. She has photos with Bill Barr in the office. There's no,
and I'm gonna tell you,
and she's gotten threats. And I would just like to say, as the story broke on X yesterday, she has received multiple threats from the office of Armstrong Williams, and I plan to expose Armstrong later today.
Wow.
Yes.
Wow.
Yes.
And so Armstrong and Williams.
No, his full name is Armstrong Williams.
Okay, his full name is Armstrong Williams. So Armstrong Williams,
he purports to be a patriot. He's a mole, a snitch. He does a lot of criminal work. He gets illegal visas for high net worth individuals, some of which are named in my post yesterday on X.
Are you able to divulge the name of the Brazilian?
And I want to break something down for y'all real quick so y'all can understand what's going on. So this is for people that ain't been following it like maybe the rest of us have. But the man that she talking about, Armstrong Williams, he supposed to be like a media person. You feel me? He supposed to be like just there for like media coverage and stuff like that. He one of the worst critics against Fani Willis. Like he always talking about Fani Willis, criticizing her and stuff like that. She's saying now that they be orchestrating this stuff, and you know what I'm saying, trying to make it seem a certain way. And he really working with Bill Barr, who was working with the Trump campaign, who's saying that it was revenge to hit Trump with this RICO. Okay. So when they hit Trump with the RICO and they locked up them and all they ate and all the co-defendants, she went to talking to the girl Patricia Lies, or however you say it, that was working for Armstrong. Okay. And she started dropping the receipts because she was in control of the paperwork. She was in control of the phone calls, delivering certain things and stuff like that, the lady Patricia. So Patricia started telling her, and you know what I'm saying? She getting threats. They all getting threats now. But this stuff is so deep what she's saying. But the dude Armstrong, he not supposed to have no kind of actual pull. She's saying that this man making fake visas for high top officials and stuff like that from other countries, and he linked in with Bill Barr. That's the attorney general, so man. And then they got the thing right. Y'all remember when Fani Willis kept going to DC? She kept flying up there to DC, and they was like she would meet with Kamala Harris. Man, they talking about how she was meeting with Armstrong and Bill Barr, man, about them RICOs, man. And it's all fraud. That's why she can't show with none of that money. I ain't got nothing bad to say about Fani. I like her, and I like my freedom even more. Listen to the people.
Whistleblower?
Her name is Patricia.
Okay, we don't need to know more than that if we don't have to.
Yes, her name is Patricia.
I want to share a clip. I found this clip. This is from your powerful, impactful. It's got over almost 3 million views on
in less than 24 hours.
In less than 24 hours. I mean, this is huge. This is, and you haven't talked to anybody about this yet. I'm sure you're going to, right?
I'm going to, definitely.
Yeah.
Well,
so we're getting this. You did speak with the New York Post. Okay. Yeah. So I found this clip. Let's. Do you mind, Trevian, if we play this real quick? Please. And then together I can stop it where we need to. You just say, "Hey, Nez, stop it," and then we can kind of give a little bit more context. But before I play,
that's just 37 minutes of it. There's an hour and 40 minutes, and that's just a snippet.
Are you going to post more of that?
I sure am.
Wow.
Yeah.
Wow. Well, you make sure you tag me because I'll share it with my audience.
Don't you worry. Thank you.
Oh, don't you worry. I love it. Okay. I love you. This is fantastic. Okay. And the reason why, we're one of the things that, you might be saying, Nez, why are you getting so giddy? Because this is a justice. This is a long time coming. It's a long time coming, not just for our country, not just for Trump, but for people who have not gotten the notoriety that they deserve and perhaps the justice they deserve, like Trevian Cutie and others, right? And so this is a really fantastic moment because the liars are being outed. The liars are being exposed. And I just value and appreciate that so much. And so if I sound excited, it's because of that. Let me bring this up real quick, Trevian, and then you can so I'm going to play this and you tell me, this is Patricia, you said?
Patricia.
This is Patricia saying that Fani called and said, "Hi, my name is Fani. You can see at the top, and I'm here to talk with Armstrong Williams, correct?" Yes. And then let's play this and see what she says.
She calls there, and we have a lot of calls with her. Bill Barr, I know that sounds insane, but Bill Barr is always in the office too. He's very close to Armstrong, and he's always there. And they're always in touch. So Nathan called the office too. Nathan Gardner also called the office a bunch of times. I don't remember exactly.
Wait a minute. Was that Nathan
Wade and his law partner.
And his law partner. Remember, everybody who's watching and listening, Nathan Wade was the special prosecutor that Fani hired illegally, really, because she used forfeiture funds. And paid him a salary that was just so exorbitant, almost $1 million. A lot of you guys already know this. I'm just keeping you up to speed. But if you didn't hear what she just said, she just said that Bill Barr was there all the time. And it's funny, too, because if I can just back up a little bit here, Trevian, sure. She said Fani was rude.
She did.
Is that a shock? I don't think that's a shock to anybody.
No.
But I want to play that one more time because she said, "Hi, my name's Fani," and then she says she was a little rude. That's an understatement right there, right? Okay, 1 second, and then Trevian, you just say, "Hey, stop! I'll explain this." Okay.
Bill Barr, I know that sounds insane, but Bill Barr is always in the office too. Wow. He's very close remember exactly his name, but I have all this. I have all the notes and information. But just before I was in touch.
Okay.
So we exchanged emails, text message, phone calls. Always Bill Barr was involved in this kind of things.
Wow.
Okay.
I saw Fani Willis one time in the office.
Okay.
A small person, black woman, a little fat.
Right.
I saw her in person. I saw her, I think it was February 27. I think it was February
23rd, according to your notes. I'll show you the notes. So it says up to 2022. 23. Okay.
Yeah, she was in DC not to met Armstrong and Bill Barr. She was doing another thing. And
where was the office?
Right.
DC.
Hey, really quickly, Trevian,
So
who's that?
I
Who's
wanted
that
to tell
speak?
people who they hear on the audio.
Yes.
So they hear Patricia,
Uh-huh.
myself, my attorney, and her husband.
Aha. Okay.
Yeah.
Okay. I see here that she says, I'm a journalist, like you said, like you confirmed. I took pictures. So Bill Barr is always there. Bill Barr is always there.
Always.
And then let's listen to what she says after this.
So Bill Barr is coming over to Armstrong Williams' office.
all the time.
Interesting.
It's near the Capitol. It's also near some far from the Fox News studios. Okay. And CNN and Fox. It's CNN and Fox News share some studio space.
Yeah.
Okay.
Bill is here on TV.
Okay.
So it is. What do you think? It's a 10-minute walk to the studio. It's less.
From a 10-minute walk.
We'll get to the address.
So it's close to DOJ too.
Yeah.
So he's always there, and like I will be honest with you, he always treated me well. He was very nice with me all the time.
And we have photographs are not great, but we have photographs of her.
Yeah.
There are the
You know,
photos.
like, okay, we can prove that they know each other.
I'm a journalist. I took
Okay.
pictures of everything.
Good.
I took pictures of that. So Bill Barr is always there, and I remember. I'm not sure. But I remember she was around to do something.
Okay.
And because she walked to the office.
Okay.
That's what I'm 100% sure. She walked, so she was around. I'm not sure if she was like in the Congress.
Hey, real quick, Trevian, what was the date of this?
February 27th, on my birthday.
Oh, wow.
Yeah, she said all this stuff get ready to come out real short.
So when was
Oh, 2023.
so that was yeah,
last year.
last year. Okay, so when was the actual occurrence of Bill Barr and Fani Willis meeting at Armstrong Williams's office?
That is actually, they met on February 27th, 2023.
Wow. And the indictment took place in August, remember, right?
Exactly. And we were verifying Fani Willis's travel records. She was in DC at that time.
She was in DC meeting with Kamala Harris.
Actually, she was it's actually on the White House records, but I just was able to confirm her travel records and they do coincide. So that was our personal investigation. We could not verify truly where she was, but we do have a confirmation of her travel in DC at that time.
So can I ask you a little bit about Armstrong Williams? Is there anything?
Thank you.
Yes,
Thank
please.
you for asking that question.
Please.
I originally was introduced to Armstrong Williams by the wife of Michael Eric Dyson, a well-known author, professor, used to teach at Georgetown. Now I believe he's teaching at, he's a professor at Vanderbilt. His wife, very kind to me all the time. We were doing some work. I was representing an American basketball player who signed a contract to play basketball in Qatar. And when he arrived, this was during COVID, when he arrived, they sent him to a slave labor camp. And I had to get him out of the slave labor camp. And we were doing some publicity throughout DC. And that's when Armstrong Williams came into the picture. I had the man's cell phone before the whistleblower, Patricia, came to me. So I don't know if you understand what Sinclair Media is. That's a Dave Smith company, very big company.
Can you tell us a little bit about? Yeah, can you tell us about them?
Armstrong Williams's media company is under Dave Smith's umbrella, Sinclair Media. So, but we do not, and Patrizia, the whistleblower, has made it clear that Dave Smith is not involved in any way.
Now, Sinclair Media and Dave Smith, can you tell us who are they exactly?
So Patrizia was looking for a job.
That's crazy.
She had met Dave Smith of Sinclair Media previously. She decided to reach out to him and express that she needed a job. And he said, oh, you know what? You can come and work for me. She thought she would be working for him directly. However, he placed her in the office of Armstrong Williams. Dave Sinclair Media, I know I've been to dinner with Dave Smith, the Tribune, WGN, those were all under the Sinclair Media company. So I've broken bread with this man and had conversations with him. Yes, and this was in Chicago. This was probably 6 years ago, maybe.
And just to be very clear, Sinclair Media does what exactly?
So it's a very big media company. I do believe that they sold the Chicago Tribune, or it was either WGN. Sinclair Media had all of these companies under its umbrella. And when the tide started turning after COVID, it started, right before COVID, it started, off-letting all of these different media companies. But Sinclair Media is very well known.
Okay. Yeah, I know WGN really well, and I know Chicago Tribune, obviously. Let me ask you this. So that clip right there where she's saying that, so Fani was there, Bill Barr was there all the time, and then Armstrong Williams's involvement connecting those two is what exactly?
All of it was in his office. Armstrong orchestrated the meeting for this to happen. Now, there's
like a mediators? Okay.
Yes, there's also a gentleman by the name of Shermichael, who used to work for the Trump administration, who Trump fired, and he's in some of these meetings planning all of this against Trump as well.
This is like vindication, right? They just want to get out.
The whistleblower named it as revenge.
Wow. So essentially, everything that all the conspiracy theories are true. They said that we were conspiracists. They called people like you a conspiracist. Oh, no, this is not weaponization of the DOJ or politicalization of the Justice Department, when in fact, what you're sharing with us right now, Trevian, and what Patrizia, the whistleblower, is sharing with us is essentially that's exactly what this was, wasn't it?
Exactly what it is. And to know that the woman who indicted me was the whistleblower is now giving me, showing us handwritten information, notes with my name on it. Fani, per the whistleblower, bringing in somebody from Facebook to put hit pieces out on myself, and Trump. And I believe she did say someone else. I just don't want to misquote. But
man, this lady said Shout and them were putting hits out on her, man. That lady got documented proof that they were trying to get her up out of there. And the summary is basically, we getting ready at 9 o'clock. They getting ready to decide about Shannon Steele, about the bonds and about the plea bargains and stuff like that. But this information came out with the whistleblower explaining why and who was behind. Oh, this the lady. Yeah, she the lady on the indictment, Trevian Cutie. So she already had a thing and been going at Fani Willis and making it a campaign. But the whistleblower who was working for Armstrong, she blowing the whistle. What's going on, Galatians? A lot. They say it's more whistleblowers too. And they done turned the other lady, the lady Patricia, she turned all this stuff over to the FBI, and the FBI came and hit her house. Y'all got to really listen to what they saying, because it explains why Fani Willis is doing all these RICOs. You feel me? The dude Bill Barr and the guy that she was just talking about, Shermichael, they used to work for Trump. They used to be, they used to be part of the Trump administration and stuff like that. And the way that they're explaining it is, these people leaked this information and they telling it. She's saying because she got to do diligence to let people know what's going on, and they don't like how Fulton County is doing. They don't like how they be treating people down there in Fulton County. I think I was locked up when they got locked up for this stuff. But I remember the dude, Harrison Floyd, he was like and I think it was her too. The only the out of everybody that got locked up, only the black people didn't get a bond. You feel me? And I think it was her. I know for a fact it was the Harrison Floyd dude. But them people got a vengeance and they started, you know what I'm saying, advocating and speaking out. And now so all the information that they had got on Fani Willis, that's what Ashley Merchant and them been trying to get them to do. You feel me? That's what they've been trying to do now, is bring them up on charges. Well, they was trying to get them to turn over the documents and the funding and all that. So the courts just said that she had to produce that stuff. Whatever it was they were trying to get, they said that she got to produce it. But somehow she said she ain't giving up or whatever. But now with the whistleblower coming out, good morning. Now with the whistleblowers coming out and having these receipts, they saying, look, all this stuff was done fraudulently. You had Bill Barr, the Attorney General, really conspiring with Armstrong and Fani Willis to manipulate these people into these RICOs. You hit Donald Trump with a RICO. Y'all seen what just happened to the RICO with YSL? Complete trash. Same thing with YFN. They have not had a successful RICO in Fulton County yet since they've been in office. That's what they saying. And that's because it was never no case there. This was all coerced and manipulated by Fani Willis, Armstrong, and Bill Barr. Sir Michael, allegedly. But they got some receipts, so check them out. And they're saying that all this is getting ready to come out here shortly.
These are all these things that Fani Willis was organizing.
And she gonna explain it to y'all, but and I was telling y'all, they took all this stuff to the FBI and stuff, and they had a hearing with Fani Willis. It was December the 5th, but Fani Willis had got with the board, the commission board. She got with somebody. The lady said, "Here you go." She got with somebody. I can't remember. She gonna tell you that. What's going on, Mimi? She gonna tell you. But she said Fani Willis got with them people and worked out some to where they couldn't come. To where they, you know what I'm saying, they didn't make her come to court. They just bypassed it. She was supposed to have that hearing on December the 5th. So then she said, well, look, what she said? They didn't have that. So they was like, well, why Buddy ain't, that's the other lady, the Patricia dude, the Patricia lady, the whistleblower. She was like, the man Armstrong won't sue her because y'all got to see that. I'm gonna play that for y'all too. When Armstrong come up and he basically say that they lying, the lady mental health, you know what I'm saying, blah, blah, squaze. So bro, poor old girl, look, the girl, Patricia, the whistleblower who got all the stuff on Armstrong, who trying to deny it. Thank you. Who trying to deny it. They like, look, the lady pull up and like, man, I got the pictures. Hey, man, this lady had her receipts. I ain't gonna lie. But she did not have a picture of Fani Willis and this man together. But she says she do have the evidence. Thank y'all for tuning in, One Life. And I just wanted to bring awareness to the behind the scene, the political side, why these RICOs are going the way they're going. Because I think a lot of people we were saying, trying to figure out, why the hell do she keep putting RICOs on people that ain't going nowhere? Now we seeing what it is. We seeing why ain't no money in the system. It don't matter how many lawsuits y'all put on Fulton County, you ain't gonna get no money from them because they ain't got no money. You feel me? The money is gone. And before you can sue, and that's what I'm trying to tell people. People got to be very cautious and very particular about the things that they do. Them folks can sit down right now and sue their jail. They can sue the bailiff. They can sue the sheriff. They can do all that, right? But all them folks got to do is resign, get terminated, get up out of there. You feel me? File for bankruptcy. You ain't getting nothing. It's a circus act. And this is why a lot of this stuff is going on. And I'm thankful that we got people like Trevian Cutie, with Harrison Floyd, myself, people now who have started to bring awareness to Fulton County so that it can change for the better because it's been messed up for far too long.
The office of Armstrong Williams in Washington, D.C. with Bill Barr present. These are the things that, as a citizen of this country who's done my, civic duty to make sure that I am a productive citizen, that I make a difference while I'm on this planet. And to know that, hearing everything that she set out against me and how it was done. And in so many words, I feel dignified as an American citizen to know that they would put this work into trying to take me down. And I feel I felt glorious hearing all of what was done against me, because guess what? If you never know how a crime is committed against you, you'll have this thing that you'll carry with you for the rest of your life because there are unanswered questions. Now I know everything. I know Fani Willis's right move and left move against me. The FBI I was in the middle of nowhere, relaxing. The FBI pulled up on me early in the morning, subpoenaed me to come and testify in the Jack Smith case in DC. His name was Special Agent Myers. He showed up, Miss Cutie. No one there should have known my name because I was in the middle of nowhere. He said, I have a subpoena for you. I said, I bet you do. He said, we're going to need you in DC in the next couple of days. And I looked at him and I said, the next couple of days, really? He said, do you plan to comply with the subpoena? I said, I plan to forward this to my attorney and we will respond accordingly. I think Americans need to know their rights. This man said that I had to be in DC in a couple of days. When I know my rights and your rights, if you are subpoenaed, you have 30 days to even respond to it.
Yeah.
So Americans need to know their rights. And I was able to evade that subpoena because I did know my rights.
You're saying they tried to bully you into showing up in less than 48 hours?
And he said a couple of days, so I'm counting that as 3 and maybe 2. Yes.
Wow. Let me ask you this. So Bill Barr was Attorney General for Trump until Trump fired him, right?
Correct.
So him colluding with Fani Willis, was he colluding with Fani Willis as a private citizen, or was he still working in some capacity to the government? Does this add any sort of heaviness to this, or does it even matter? Is it insignificant?
So as I understand it, Bill Barr was no longer Attorney General, and I could be wrong, but the Patricia, English is not her first language, so I don't want to misspeak. However, Ben Carson was very good friends with Armstrong Williams.
How does Ben Carson fit into this?
I'm about to tell you.
Please.
Yes. So Ben Carson believed that Armstrong Williams was his friend. Bill Barr used Armstrong Williams to siphon information per the whistleblower about President Trump, where President Trump would be, what he was going to be doing, information that Bill Barr needed to turn over to people who were going to press charges against President Trump. So Ben Carson, by right now, I will say he involuntarily was a mole, but when you are subjugated to classified information, you should not be sharing it with people like Armstrong Williams that turned around and gave the information per the whistleblower to Bill Barr. And now this information that was shared was put in your trumped up charges, or in the trumped up charges against President Trump. So whether Ben Carson unknowingly or unwittingly gave this information to Armstrong Williams, who gave it to Bill Barr, who used it against President Trump, you are not supposed to be sharing that information regardless. So it's still a crime on behalf of Ben Carson.
So he trusted Armstrong Williams.
He trusted Armstrong Williams per the whistleblower.
Per the whistleblower. Okay. I have a little, I think I have a snippet here I could play.
Yeah.
Let's see if this, Ben Carson, that's a new one. That's insane. I remember when you first shared this, there was a lot of talk about Ben Carson being involved, but perhaps, like you said, Ben Carson was involved unbeknownst to him in this. He was almost like a pawn in this nefarious.
Bill Barr's biatch in this situation.
That's a technical term, ladies and gentlemen.
You know, that's what happened, unfortunately. And I was very sad listening to the whistleblower explain this in detail. If you want to run that clip, she basically said there was so much information she saw Ben Carson give to Armstrong Williams, give to Bill Barr, or other people. It wasn't just Bill Barr.
I want to play that clip right now, and then I'm going to come back and I want to ask you some questions, Trevian, about why we should trust the whistleblower and what is the harm, just playing devil's advocate, because there's people out there right now who are listening and watching going, so what that Bill Barr helped Fani Willis? He wasn't attorney general. He got fired. Maybe he was pissed off, but did he actually do anything illegal? Now, I'm not saying that's what I think. But I know there's a lot of people out there that might be watching going, so what? But let's play this clip first, and then we'll get to that. Hold on one second. Let me see if this relates to Ben Carson. Let's listen in here.
I left the office with the phones that we used.
Okay.
And that's why I have her personal phone number that I exchanged WhatsApp message with her. And one day I was like, maybe they don't care about Venezuela that much, but that would be like the most important thing for me because that's about people like close to me. Right. But I think for him it's not that. For him it's about the documents that I got in.
Okay.
Bill Barr. So these notes I know he had to Fani Willis and Nathan Wade.
Oh, the one that I sent off the email? Yeah, like that was one day after the meeting. I think it was, I'm not sure if it was, I did before, but I did after for sure. It was not just one time. Barr went to the office and he asked me to send over mail, like mail, the one in
Right.
And I didn't check the documents because it was like in a, I don't know how to say English, it was like in an envelope. But I remember that was like confidential. That was like a very red mark as confidential.
Okay.
And I sent to her house. That's why I have her house address. I sent to her house these documents. And I know this document was about the case she was bringing after people.
And she has she has reason to believe these were classified documents. That's the word she told me when I asked her about it. They were from his time as AG. And he retained. And Armstrong, you'll see the text message. This is too much for one night. We can communicate. But in this particular incident, Armstrong forced my wife to go to the office in the morning. He wanted her to send these documents. And she had recently, she had illegal. I want to keep emphasizing that here. But these are documents that somehow Bill Barr retained that were mailed to at one time. I can't remember if this was Fani's home address, which, or you'll see this, I can't remember if this is Fani's home address or this is David Wade's. That's one of the phone numbers. She has both.
I think the one is the files is her address, the one that
Fani Willis's home address?
Yes. She was mailing documents from Bill Barr to Fani Willis's home address marked confidential.
Okay, now let me ask you this. Wow, that's phenomenal. At the very least, Bill Barr could have disclosed he was involved in some capacity. But for those who are playing, just to play devil's advocate, for those who are skeptical and saying, well, how can we trust Patricia? What's the big deal of Bill Barr being involved? I mean, obviously, you and I both know why the big deal is. Right. What would you say to people who are skeptical?
I will say that this woman figured out eventually that Armstrong Williams and all of his, clan were doing illegal things, and she was involved in it. And she realized that they had put her in a position that she was also now involved. They attempted to, so Patricia took all of the documents showing Armstrong Williams and others' involvement. She also took the burner phones that were used to make these deals, which I have seen myself. I have taken screenshot video of the contacts, inside these burner phones. And to my surprise,
phones, y'all.
I saw
this finna get
Judge Juan Mershon.
No.
Yes.
Wait. Time out.
I have the video.
Oh my God.
Recording.
Okay,
yes.
Time out. Two things. Number one, burner phones implicate you're doing something nefarious.
Question. And they're the really short, black, crazy looking ones that are high, the real people in the world have those phones. I've never seen a burner phone that looked like that. Okay. It was as basic as you could get, but you knew, and she was scrolling through the phone. And I mean, when I tell you everybody you would think shouldn't be in those phones are in those phones, which I decided to record a video of those contacts. There's no way Armstrong Williams or anybody in that office should be doing business with Juan Mershon if he purports to be a patriot, America first.
Or
Armstrong Williams is the devil.
Or even more prescient, he claims there's no conflict of interest.
Exactly.
Fake Don Juan Mershon, as well as Fani, as well as Kamala, as well as Biden, as well as all of them involved, Jack Smith, Letitia James, etc. They all claim there's no conflict of interest.
Exactly.
My
lawyer has all of this.
Can you tell us who else was in the burner phones, or you can't?
I got to go back and look at the video. Maybe we can do.
Okay. But you're gonna when you have the right, you're gonna share the video with me.
I'm going to share with you first. You're exactly right.
Okay, so Ben Carson, we're sort of giving Ben Carson like a semi pass here. Is that what we're doing, basically?
I'm not. I cannot, because
talk to me.
In his position,
okay,
you have an obligation to keep the information, the business of this country, confidential.
That's true.
That is your oath of being in that office, being in that administration.
Right.
So whether you did it unwittingly, involuntarily, it doesn't matter to me.
Even if he was being duped, shame on him. Right?
Shame on, and he's such a nice guy, such a great guy. But
who is Armstrong Williams? Who is this guy?
Armstrong Williams, you will find, has more tentacles in crime in high levels in this country than most people. He has done, when I saw the burner phones that Patricia had and some of the people, there was no way this should have been coming out of an office of a black man who purports to be simply a media personality. He what they call it is they call it visa lobbying. It's not a real thing. But what happens is they take, by request that they're paid from these high net worth people, and they go find different politicians that will help get these visas passed through. Patricia, the whistleblower, had to put together the business plan for these visas, for these, for them to shop around. There is audio that outlines exactly how these illegal visas were processed, and sometimes even different countries played part in getting these visas approved. So,
hold on.
I mean, I feel like, so let me just explain how big this is for Patricia. Patricia was charged with wire fraud, had to leave the country.
And she breaking it down for y'all. Her life already in danger when she went against Fani Willis. She said earlier that Fani Willis was putting hits out on her. She got that Trevian money. If y'all don't remember her, she worked with Kanye West. I think she worked with R. Kelly. Like, she's a known public journalist and stuff like that. And she got locked up and charged as a co-conspirator in the Trump situation that Fani Willis did. So the lady that she talking about, Patricia, what she was explaining is why these RICOs came about and how Bill Barr was the one behind the Trump RICO. And that's how Fani Willis basically had all these RICOs going on. And Bill Barr was the attorney general on the Trump campaign, but he was fired along with Sir Michael. Sir Michael, I don't really know much about him, but she was talking about him earlier. And they running all this stuff through a media company that Armstrong Williams worked for, but he supposed to be like, you know, a media person. But they running all these RICOs and stuff through him, and he is the connection from Bill Barr to Fani Willis, and he was getting information. Bill Barr was using Armstrong to get information from Ben Carson on Donald Trump, and that's how he was able to go. That's how, what's his name? I just told y'all who getting it, was able to go back. Bill Barr was able to go back and give it to Fani Willis to even create the RICO charges and stuff like that. Like, it's a whole bunch of corrupt stuff going on. And by her, like, her whole thing is to, first of all, get justice, get Fani Willis up out of Fulton County. They hate how Fulton County is being ran. It's done been under investigation by the Department of Justice. It's been found to be in several violations. They got several lawsuits on there. Everybody know what's going on with Fulton County Jail now, and it's done. Awareness has been brought to the entire situation. And so you have people that are advocates for this stuff. You got some people that don't like the jail. You got some people that's got a problem with the courts, and she happens to have a problem with Fani Willis. She don't like how Fani Willis did it. She don't like how Fani Willis. She said that she was locked up and put into the RICO because a lady reached out to her. Good morning. Reached out to her and said, well, look, a lady reached out to her. She went to Georgia to help the lady. Some kind of way they got her on body cam helping the lady, and they turned around. And I guess they said that it was like, she said, not really witness tampering, but it was something like that. You know what I'm saying? Something to a witness or something. So she got caught up in the RICO. And, you know, so that's why she had started. That's why her journey started. Same thing with Harrison Floyd. Like I was telling y'all, when they locked him up, he didn't get a bond. He had to sit in Wright Street 90 days. So he, you know, all these are things that they, that's what, now she say that she went to go help the lady. She, and Fani Willis, you know, made it seem like some more stuff and put charges on her, but she's saying that stuff ain't true. Now, that's just what she's saying. And she's saying behind that, she producing. She got her receipts too. Her and this lady, man, they got some stuff. I was just starting from the beginning because even the man tried to come up and debunk it, and he couldn't really debunk it. Armstrong, and when Nez was like, "Look, I'm finna put her up here," he got him hook on up out of there. He got on up out of there. Oh, but yeah, hold on, check it out. She telling, look, they said she's trying to take Fani Willis down, and she said the stuff that she got will end Fani Willis' career forever, and that's what she's trying to do. She's trying to expose.
Because they tried to kill her. The FBI raided their home in Virginia. She was able to get political asylum in Mexico. The FBI came to her home in Mexico. She has an emergency wristband that she wears with an emergency button. The FBI showed up. She pushed the button. Mexican authorities were fighting with the FBI. She has this recorded. Like, it's crazy. All of this is just so it's mind-blowing, but she kept records like nobody I've ever seen. So there's video.
Good for her.
There's audio, there's, you know, paperwork, dated, timed, everything. And that's why I think the American people should know, coming from me, I have a lot of skin in the game. I don't need anything to ruin my chances of the freedom that I deserve to have it, you know, untainted by people like Fani Willis in Fulton County or anybody else. And I did my diligence, my lawyer did the diligence, and there were some things that we were able to corroborate in addition to all of the evidence that we were able to see firsthand and take recordings of.
Wow.
Yes.
I can't wait for this. And by the way, I wonder how this impacts the fact that, again, she's the last case against Trump and you and others. The appellate court just canceled oral arguments, which was the appeal that was won by you and many. You were involved in that appeal, correct?
December 5th, we were supposed to have a hearing to disqualify Fani Willis. In the interim, I believe it was November 17th, or I don't know when she did it, but Fani Willis, in my opinion, and it's very likely because the evidence shows, she struck a deal with the Georgia Court of Appeals to get the hearing canceled. Therefore, the world did not get to see and hear and visualize the evidence that we had against Fani Willis, because we would have destroyed her career forever. Now, that hearing qualified Fani Willis. In the interim, I believe it was November 17th, or I don't know when she did it, but Fani Willis, in my opinion, and it's very likely because the evidence shows, she struck a deal with the Georgia Court of Appeals to get the hearing canceled. Therefore, the world did not get to see and hear and visualize the evidence that we had against Fani Willis, because we would have destroyed her career forever. Now, that hearing canceled. If you look at the filing, we cannot even see who filed the document to cancel the hearing, which you always are able to see who filed anything into a court case. Why is it that we don't know who filed it? How does it just get entered into record? The hearing gets canceled. Fani Willis is walking free from the world getting to hear how bad of a person and how many things she did that would have destroyed her career.
Hold on. The thing quite didn't start. Morning, Kiki. How you feeling? Man. Hey, what's going on, Don? What the hell did I just do? Y'all think Yak gotta go get a bond. They gotta give him a bond though, unless he been indicted. No, hold on.
What the flow will be.
I could run downstairs at 9:30, just Winter's very brief.
I was told there's something in 1C, there's something next door, there's something in here that is of interest to lots of folks. I'm a little more focused on all the murder cases, but so will you be handling all of the bond hearings? There's one add-on that is sex crime. Okay, I saw Ms. Clark kind of briefly in the courtroom and then she left.
Sure, there's a couple who have, I think there's 3 defendants who have murder counts, but also the cat cases, so she'll be handling those as well.
Okay, got it. Yeah, there's a couple whose kid OD. She'll do that. Okay, and then the add-on with, I think that's Mr. Tevis is handling that. Okay. Is she coming back here? All right. And on the defense side, sir, do you have the good fortune of handling all of the appointed cases?
Your Honor, as far as I know, I'm here for just Robert Powell.
Just one?
Yes.
Okay.
And I'm not sure that Mr. Powell will be brought up here. It's my understanding he's in Gwinnett County.
Oh,
That's there.
okay. Well, that'll streamline that one. Okay. And you are?
Attorney here.
My name Judge McBurney.
Okay.
I think Judge McBurney pretty fair. I can't.
But that's the only one you've got?
Yes.
Okay.
Hey, good morning. Good morning. How you doing? How everybody feeling? Oh Lord, I forgot all about that. Caleb, I'm supposed to be representing him in this, ain't it? Man, I forgot all about that, man. Lord Jesus. I believe he might get a bond though. So. I forgot all about Shout. Dang. She might get him a bun though. He's no Bernie. I don't see him not getting a bun. He ain't got nothing but an ad. It is weird. What she got? We finna find out today though, okay? It's gonna be some information. I think Shannon caught the cameras in there. I think the wives. I know we got I would have.
Will Mr. Rao be able to stay? Will you be able to stay here if Mr. Bate has to go to 1C, or you guys are there?
I'm sure we can text him.
Okay.
Yeah, he can stay. I don't know later.
Okay. We'll see. Currently, we have no defendants.
Yeah.
Mr. Mursajan, do you have a colleague who will be covering? We have 10 bond hearings, and in reviewing them last night, a number of them look like they would be appointed counsel. I know there's going to be one conflict issue because it's co-defendants, but I'm surprised you have only one, and you're lucky if that person's not here.
To my knowledge, Your Honor, I haven't spoken with any other attorneys about being here for the bond, but I can reach out.
Okay. Great. Who typically covers this calendar?
We just have the clients are assigned to us based on when they have their first appearance.
Okay.
So I would have had Mr. Powell today. So
Do you have it already? I have, but I don't have it together. Uh-oh.
Mr. Beatty hired private counsel, as I understand, so I was going to get from Mr. Powell. The other defendants should have their public defenders as they were assigned to them.
Okay, yeah, if you do a little outreach, that would be great. All right, are there any attorneys here for bond hearings for someone whose name is not Kendrick? Yes, ma'am, you are here for whom?
I have Carl Washington and Daryl Williams.
So Carl Washington's been indicted and assigned to Judge Leffridge, so we will not be hearing bond for Mr. Washington today. What was the other one? Daryl Williams, I got that one. And you are? Can you say your last name again? Isola? How would you spell that? Okay. So once Mr. Williams is up, we'll try to do that one. Judge Leffridge. So that won't be heard today. That's just, he's been indicted. And so any issues or questions about bond will be covered by Judge Leffridge, to whom his case was assigned. So I don't even think he was brought over today. He may have been, but I won't be addressing bond because it's now assigned to a judge. Good morning, Ms. Clark.
Morning, Your Honor.
So you'll be handling the bond hearing for, assuming we get lawyers, for Kuykendall and McCaslin, as well as Mr. Chevis's client.
By default, need to come on. Shit. Now you been Fulton County all day with him. Mind you, he probably done been up since 4 o'clock in the morning. Going for that bond. What you gonna do for me, Matt Barnett? Trying to get me, trying to get up out of here, Mac Barnett. Big. This is crazy, man. They probably give him a bond though. I don't see why they wouldn't give him a bond. I mean the charges, yeah, but whatever. They gonna give him a bond on the ass, y'all.
Pardon me?
I didn't just see a calendar for this date. I don't know about it because I looked up my concept, honestly. So I get a calendar for that to splits.
Okay, let me get you a calendar. Ms. Nelson, can you text me to whom you sent the presiding bond calendar on the public defender side? Because it sounded like it might not have gotten over there.
I went to our team, and so it didn't go to any private attorney. I mean, it didn't go to the public defender's main office. It went to our team.
Meaning it went to Ms. Rios and Ms. Wood.
Correct.
Mick Burn.
Okay, I'll print you one.
Thank you. And additionally,
I got an extra copy.
Of the bond calendar?
Yeah.
Great, here it comes.
additionally, I did not file a bond motion for this hearing today, so I also need to see why other attorneys are not aware here.
Well, we shouldn't be calendaring things where there aren't bond motions. We're gonna need to work on our process.
You're not giving them no bond.
My client has only been in custody
$20,000. Yeah, let's take some.
Well, that's what all these are, though. These are the ones where there was a bond deferral. So at first appearance, because of your client's charges, murder, and all these other folks, with one exception where it's a child sex offense or a rape or something, they're all murder cases. And so they never got a crack at a bond hearing. And so we automatically put them on these calendars. But you can say no thank you at this point. There's not a mandatory bond hearing.
Yes, sir, that was my plan to well, not exactly withdraw the motion, but say we're not ready for a bond hearing this time.
Okay.
On this policy.
Okay.
I will reach out to the other attorneys and figure out.
Okay, so I should take Powell off because you don't want to go forward with bond today. It'll stay with me. It's until indicted. Bond hearing will be here. So if you want to defer the bond hearing to another day, that's good to know. I just want to make that notation. Okay, thanks. Yeah. We'll see, but that may make it go more quickly.
But yeah.
Right. Okay. All right, so if there was anyone here for Mr. Powell, and the deceased in that case is Mr. Woods, we're not going forward with that hearing today. And we'll see what other announcements we get.
Wow, you're looking to figure out what, I forget the attorney's name, but that seems to be the running theme of these, the positions today. There's no bond motions filed. Like in, for example, Mr. Drinker, there's no bond motion filed.
Not even, sometimes there's just language to that effect with the first, when someone enters an appearance. I don't know what's triggering it, but we're gonna need to rethink our approach and just slapping everything down that got deferred for a hearing. And I think the default is you could not have had a bond hearing even if you asked for one, if you're Mr. Drinker, just using that as an example, because of the charges. Mr. Drinker, there are 2 decedents? Did I read the, okay. So, but that may explain why there aren't colleagues of Mr. Mursad here, that they weren't planning on arguing bond at this point. That was streamlined today.
Probably why there isn't an attorney listed on the calendar either. There's
Yeah.
a lot of them there.
So,
all we can do is one of the Powells, is Roderick Powell your client?
Yes,
Do you want to talk to him, or
I can speak to everyone.
we're skipping, so he can go back down Roderick Powell. And we have a lawyer for Daryl Williams. Daryl Williams is here. Okay, so we can do that. Daryl Williams and Robinson Baker are the ones that are ready to go.
Wait a minute.
do you have one of the,
Max,
you're just a hanger on? That's what I thought, okay. You got nothing to do these days.
Right, no, I'm actually next door. I'm next door, but yes, I'm looking for things to do.
Okay, I got some
Good to see you,
things.
Judge.
Yeah, let me know. Could do some trials next year. Yeah.
This might have been after your time. Did you ever go to University of South Carolina for the trial advocacy center over there as a AUSA?
Yeah, a lot. That was where all our trainings were.
Right, right.
Yeah.
I went to school there, and last week, Victoria, she was a mock judge they have the district court judges go down and help train. So so I got to go back down there. And that was always on campus when I was there. Or towards the end of my time there, was on campus, but I never really took note of what it was. It was just some fancy building that I knew nothing about.
Because the residences are there, and there's cafeteria, and then all the classrooms.
Well, I heard the residences aren't that great. They put us up in a hotel right next to it called The Graduate. It was a good time. So I got to take Hollis down and show them where I went to school and everything.
Excellent. Your family event.
Yep.
We've got Baker. Okay. Mr. Tevis, you ready to go?
Why not purple and gold?
Ms.
How
Clark,
you feeling today?
We're gonna do Mr. Robinson Baker. That's who we got.
Yeah. Well, I know that dog did have to go out of town, but you don't remember Caleb Bumper filed an entry of appearance on for him. I think Shannon still well too. It's embarrassing, y'all. I be hating this stuff. So if you're coming in the courtroom, you know, trying to get a bond. I hate this. I hate it. I hate it. I hate it. Boy.
I'm just saying. Yeah, that's all. No.
All right, Ms. Rivers, are you ready? Okay, we're going on the record in 24 PI 008168. It's State versus Tyreek Robinson Baker. Good morning, Mr. Robinson Baker. I'm Judge McBurney. I don't think we've met before, but your case has been assigned to me just for bond purposes. The state may at some point indict you for what you were arrested for. That'll be randomly assigned to some judge. It might come to me. Chances are it will go to a different judge. But as long as there is a question about bond in your case, then Mr. Tevis or Mr. Wolf, one of the lawyers working on your case, will bring that to me. So that's all we're working through today. Mr. Tevis, you are here on behalf of Mr. Wolf?
Yes, Judge.
Great, and we have Ms. Clark for the state. Mr. Tevis, I am ready to hear from you as to why Mr. Robinson Baker is a good candidate for bond and what that bond should look like.
He gonna give everybody a bond today.
Judge, you of all people are one of the are very well versed in the applicable case law that's going to be considered when establishing bond. But I would like to just go through 3 or 4 cases that have some pretty, I think, powerful language that is often forgotten in this building. That I want to argue against the backdrop of that. So first of all, everybody's famous case in Georgia, Ayala, right? The purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of that person in court for trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until and unless the state demonstrates guilt beyond a reasonable doubt. That is Vanderford versus Brand. In some limited circumstances, pretrial detention is permissible as a regulation serving a legitimate and sufficiently compelling government interest. And to that end, pretrial detention may be a permissible regulation rather than an impermissible punishment if it is rationally connected to a non-punitive purpose and is not excessive in relation to that purpose. And that is Carr v. State 303, Georgia 853 from 2018, which quotes United States versus Salerno. In our society, liberty is the norm.
I ain't gonna lie,
And detention prior to trial or without a trial is a carefully limited exception. And what that means is that the default position should be that a person is released prior to trial. That is the default position. We don't say this person has serious charges, they should stay in jail, because they haven't proven, the state has not proven those charges beyond a reasonable doubt. The defendant is always going to be at a disadvantage. We do not have the benefit of discovery. We don't have any of the information on which the accuser gave to the police that caused the warrant to be issued in this case. And so with that in mind, I suspect, as in the many hundreds, if not thousands of bond hearings I've done, the state will rely heavily on the facts, because the bond factors are favorable to Mr. Baker. He's 27 years old. He was born and raised in Marietta, Georgia. He went to Sprayberry High School. He graduated from high school in 2015. He worked throughout high school. He worked at a Wendy's. He also did deliveries for his uncle's trucking company. He has continued to work doing that part-time upon graduation, and also worked for FedEx making deliveries and working in their warehouse. He did that until he was involved in an auto accident as a passenger in a FedEx truck and was injured. He stopped working there. He then worked for AQC Traffic Control, which does construction projects where they, divert traffic and make sure that that's a safe environment. He has a history of employment here in Georgia. He has strong ties here in Georgia. His parents are here in the back, if you could stand up. And his mother, I think, was in the hallway. She may not have had her ID because the media case did not let him in.
Right.
But his family is here. They're in constant contact with our office. If he's released on bond, Mr. Baker would reside with them in East Point. I don't have a GCIC, but I am aware that he has one prior incident involving, I believe, marijuana, and there was a firearm in the vehicle. Not his, but I believe that he either has a charge or was sentenced in that case. I'm not aware of anything else that would show that he's a danger to the community or risk of committing further felonies. On paper and in reality, he is very tied to the community. There's no risk of fleeing here. There's nothing that would indicate that there's going to be intimidation of witnesses or anything like that. In fact, a preliminary hearing was conducted. We have a transcript of the audio of that I've reviewed, and it was the opposite. The alleged victim in this case called him repeatedly, I think 12 or 13 times, and demanded that he provide money to her, and threats were made to him, but nothing in the other direction came out at the preliminary hearing. I can go into the facts of that. I'd rather not, because true to my word, I want to say that bond hearings are not about the facts of the case, but if the state is going to get into that, then I will come up and would like to rebut whatever those arguments are. But given his presumption of innocence, he is factually innocent. He is legally innocent. The Constitution of the United States and Georgia both require that we stand here right now, assuming he has not done the thing that is on the calendar. So looking strictly at those bond factors, he does qualify. He should be given a bond. And we would ask that bond not exceed $50,000, even though that bond is going to require his community, his family, his friends, his extended family to pool their money together to be able to even make a bond under those circumstances. But there should be nothing, it is not required to be exorbitantly high just to ensure that somebody returns to court. I mean, this is his community. So we would ask the court to take that into account when setting the bond.
But not a particular dollar amount?
I said no more than 50,000, Judge. I think, I believe that 25,000 would be appropriate. I know your background, having worked in federal court. I have clients with extremely serious, complex charges with life sentences at the end who are released without money that are allowed to come to court and turn themselves in. I wish we did that more at the state level, but I'm cognizant of the fact that the common practice to set a high bond, which in all honesty is, enriching the bonding company, but I don't think that really it does any more to ensure that a client does or doesn't come to court.
Where would your client stay if he posted bonds?
He would live with his parents in East Point. I can provide the address off the record.
Okay.
If we need to do
and
that.
That's where he was living before, or that would be a new address for him?
No, that's where his family lived then.
Okay.
Yeah.
The warrant for this was sworn out in June, and your client wasn't arrested for many months. Any insight into that gap?
I don't have information on that. It also came out at the prelim that the incident date was supposedly in March. And so I think there was one that was a
May. It's May.
I'm sorry, there's a delayed outcry.
That could be, but the incident date was May
23rd or something like that.
May 3rd. And then the warrant is in June, and then an arrest isn't until late. I'm just curious if you had any insight into the gap between June and November.
I believe that police were in touch with him, and I think that Mr. Wolf arranged for him to be turned in on that, but I don't have details as to why there was a gap in that. Obviously, it wasn't a situation where he's on the run or anything like that. I'm not sure if they were in discussions or talking to him, hey, we'd like you to come in and talk, and they were not effectuating the warrant because they were hoping that he would come in and speak with them.
Right.
But I don't have information that he was fleeing or anything like that.
Okay. All right.
Thank you.
Ms. Clark. Oh, Ms. Clark, before you go, you will come on. I could tell you good morning. Ms. Jackson, how are you doing?
Oh, I'm great. How are you, Your Honor?
I'm well. This was an add-on calendar that came out late yesterday, so I don't know if you had a chance to look up Mr. Robinson Baker's criminal history.
Yes, I do have it, Your Honor.
Great, if you'd share that, please.
Yes, sir. He has 4 cycles. The last arrest was August the 24th, 2021 in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a crime. He does appear to be on first offender probation in Cobb County for possession of marijuana with the intent to distribute and possession of a firearm during commission of a felony. That disposition date was February the 1st, 2023, and the term is for 5 years. He does have 1 prior misdemeanor conviction in 2022 in Cobb County for a non-fingerprintable offense. Nothing in addition.
Thank you so much. Officer Evans, I wasn't going to be calling on you today, I didn't think, but do you know if there is a warrant in the system for Mr. Robinson Baker for his probation out of Cobb in light of this situation?
Good morning, Your Honor. Yes, Your Honor, there is an active
I can't hear you. It's odd. You're not muted.
Warrant at this time.
Hear you. I knew it. They got a warrant. They got a hold on him.
Your Honor, can you hear me?
I knew when the judge said, when Shouter just said he was on that first offender probation. Y'all heard him, but they go that.
Your Honor.
Again. Nah, that's all. I think he said.
Can you hear me, Your Honor?
Other people can hear you. That's peculiar. Some of my staff said they could hear you, but it's not coming into the courtroom. I don't know what that deal is.
He is on active
probation. Type in the chat whether there's a warrant.
They're gonna give him the bond, but Cobb County gonna come and give him.
He is on. Yeah, he does have.
Cobb County liable to come and give him. Violate.
That's what I need to know. Appreciate it, Ms. Clark.
Good morning, Your Honor.
Good morning.
So to answer, I just wanted to start to answer your question about why there was a space in time from when the warrant was sworn out and then when the defendant was actually arrested. From speaking with Detective Shields, he's indicated that he had been speaking communication with the defendant. He was trying to give himself an opportunity to turn himself in. And after a few months, the defendant did not turn himself in. So that is when he went ahead and issued the fugitive warrant to have him arrested.
Okay.
So
and
that
Mr.
is
Tevis said something about Mr. Wolf getting Mr. Robinson Baker to turn himself in. Your understanding is contrary to that he was given an opportunity to do that, but that's not ultimately how it played out?
Yes, Your Honor. That's not, so in lieu of that, that is why that you have the delay in the arrest there.
Okay.
And Your Honor, counsel opposite refers to, he is correct. A person is innocent until proven guilty, but we're not here for that. We're here for bond. And to address that, we're looking at the Ayala factors. Your Honor, the state wants to bring the first reason we feel that the defendant, risk of flight, it seems that based on counsel office's information, he seems to have strong ties to the community. However, a threat or danger to the people. Want to point out the fact that the defendant does have a past DUI conviction. Have a past DUI conviction, as well as showing the fact that, bringing the court's attention to the fact that when he was out on bond in Cobb County State Court for the DUI arrest, he was subsequently arrested in Cobb County after that on 8/24/2021 for a drug possession charge, felony charge, Cobb County Sheriff's Department. That is on cycle 2. That indicates, Your Honor, that the defendant fails to comply with court orders because he was on bond at the time. So I wanted to highlight that as well. Risk of committing felonies pending trial. The defendant currently, based on my review of the GCIC, is currently on probation with Cobb County for a marijuana distribution charge as well as a gun charge. He had a total of 7 years. The gun charge, of course, was 5 consecutive, so he is still on probation for that. Based on my review of jail booking and Odyssey, it indicates that Cobb actually has a hold that they placed that says no bond on that. So I'm pretty sure that is likely because of this arrest.
I told y'all.
There is a strong risk of intimidating witnesses, Your Honor. In this particular case, the victim knows who the defendant is.
Now, Paige, the other wife.
There's a young lady, Kim Yee, who actually was a friend of the victims at one point. She actually ended up coming over to the place where the incident location, where the assault happened. So these people know each other, and there is an intent to intimidate the witnesses. Ms. Head, the victim in this case, says she fears for her life, and that she does not wish for him to have bond. She is actually has provided a statement to our victim witness advocate that she'll read for us. But this is a serious capital felony crime, despite counsel opposite's suggestion. It is the nature of the crime does warrant a no bond status. And that's what the state is asking for. We believe it's appropriate in this case because the defendant is currently on probation. He has shown that he does not comply with court rules as he has violated bond orders when he was actually on probation. And as I said, he's on probation for the drug marijuana with intent to distribute and the firearm charge out of Cobb County. I think that he has a high risk of intimidating witnesses because of the fact that there is a friendship between the female that was assaulted. I think the roommate or something was also he knows the defendant. So there are a lot of people that the defendant will have access to. And so for those reasons, I think that bond should be denied.
All right, thank you, Ms. Clark. So, Mr. Tevis, you had asked to have rebuttal time. You certainly can have that. I've asked you to include in there what more you can add, because I believe it was your client's father was sort of raising his hand on this issue of the delayed turn-in. Yes. Getting more mysterious to me. And it's not dispositive here. Sure. I think the Cobb situation is for a temporary ruling that I'm going to make. But if you could clear up as best you're able, knowing that you're parachuting in as well, sure, what your understanding is with, hey, you should turn yourself in. I'm not turning myself in. However that played out. Sure. My understanding is that the police were talking with Mr. Baker Robinson. They wanted him to come in, as I said before, make statements, talk to them. He was waiting to hire counsel. He also had some private family medical issue he was trying not to go in about. I've checked our records. Mr. Wolf was hired at the beginning of November. I know that they were talking and meeting with him in October. And so the last couple months were, Mr. Wolf was talking to
police about arranging a turn-in at the jail, which they did, and they surrendered him.
So ultimately, there may well have been before, I'm gonna call it your firms, but before the collective legal involvement of you and Mr. Wolf and others, who knows, there may have been some back and forth, and the police may have perceived that your client was reluctant.
Right.
It's not like he's under an obligation, but
Of
he
course.
was reluctant. But in the end, the way that your client went into custody is that a lawyer escorted him to the county jail or wherever.
Correct. He was surrendered to Fulton County Jail.
Got it. And the state's perspective is, gosh, that took a whole lot longer than it should have if this was someone who was coming in to say, hey, let's clear this up.
Sure.
And I understand it, and that's a reasonable perspective. Anything else you wanted to add?
Sure. I could guess that probably part of the delay could have also been, if we're guessing, that police were just kind of lazy in this case. I mean, you can call someone and say they have to turn themselves in, but in reading the preliminary transcript, interestingly, that the state brought up, hey, well, let me back up on that. The buzzwords that I'm hearing from the state that I usually hear are, I think he's a dangerous community. We believe, the state always believes that, they always think that, and they always oppose bond. I mean, the credibility in the building, there aren't even cases where they consent to bond at first appearance, not even just serious violent felonies. And the state is correct that the court can and should consider the severity of the offense when setting bond conditions and the bond amount. But to say that the severity of the offense disqualifies from some bond is in direct contravention of Supreme Court precedent, Georgia statute, U.S. Constitution. That's just not the case. Ayala is a murder case. That's where we get all these good languages and everybody quotes it when in fact it's actually codified in the statute. So the charge itself is not dispositive. With respect to he knows people, so we think he's a danger, both of those witnesses testified for the defense at the preliminary hearing, contrary to what the victim alleged. They were both present. The victim, they said, called us and said, hey, are we drinking tonight? Can I come over? She showed up with an open bottle. She was pouring out, taking multiple shots, all of those things. That is not evidence that he is a danger in any way, shape, or form. Both of those witnesses testified that they were there, they didn't hear anything, they saw them together, she was cuddling in bed with him, all these things. So at the outset, even though the offense looks serious, there are various flavors of what this charge could be. Georgia has no degrees. Something that's ultra serious, violent, stranger on stranger is the same thing as people were drinking and they wake up and don't remember what happened. But that is not what was happening here. Both of those people that the state cited testified, were called by the defense under oath and directly contradicted what the alleged victim in this case said. So as far as the severity of the offense, the charge is very serious. As far as the strength of the case, we would contend it is not. And so far, he's still continuing to be incarcerated on a case that he's presumed innocent, in which we don't believe is a factually strong case for the state. So because of all of those things, we would ask that, again, the bond not exceed $50,000. We don't care if he's confined to an ankle monitor or even home confinement except for work, but he should not continue to be held in custody with no bond, given the light of he meets all the statutory factors. And again, the strength of the state's case at a fully drawn out preliminary hearing with an officer and witnesses was more favorable to the defendant.
Okay. Well, it wasn't, I guess, so favorable to the defendant. Judge Brooks still found probable cause to bind it over.
Judge, that's such a low standard.
But it's not that she said, I'm dismissing this charge.
Right.
Okay. All right. Is it Baker Robinson or Robinson Baker? I apologize if I was reading off the calendar I had. How do you say your last name?
Robinson Baker.
I got it right. Good. Mr. Robinson Baker, I'm going to leave you in a no bond status for just one reason, and it's a reason that can be addressed. You're on first offender probation out of Cobb. That's a delicate situation for you. This has come up while you're on first offender probation. Cobb has issued a warrant saying we need to see Mr. Robinson Baker to talk about what was going on in May of this year while he was on first offender probation for the marijuana and gun case. And I want to get you there so that can be addressed. Should that be addressed, and the only thing left holding you in custody is this no bond situation, we'll reconvene and we'll have this conversation again. Your lawyers will have a little bit more time. They might be able to produce a couple of these witnesses that they were talking about. And your situation, I've heard about the stability of your work and your household situation and all that. I won't need to hear that again. But what has come up most prominently is that you actually have a warrant, and I need to make sure you get to Cobb. So I'll do that. You and a lawyer in Cobb will figure out what the consequences are, if any, for having been arrested in this situation on your first offender probation. And once that's been resolved, you come back here and we'll revisit this question of bond, and there won't be that cloud of, wait a minute, I could give you a $1 bond right now and you don't get out. You would go straight to Cobb. And I want to have that dealt with, and then that'll be off the ledger, and we'll figure out what kind of bond, if any, makes sense in your case. Any questions about that? Okay, Mr. Tevis, anything else on behalf of Mr. Robinson Baker?
Judge, just questioning the mechanics of how we're effectuating getting to Cobb. This would just be some kind of transport order, because he'll have to be released from this hold to get to Cobb.
Right, we'll work with Cobb on that so that then there's a hold put back in place. But we've done this before where someone goes to a neighboring jurisdiction. If it was Pennsylvania, I wouldn't be comfortable that we necessarily get them back, but it's an adjacent county. And so I'll work on the logistics of getting Mr. Robinson Baker there. And then I know you or Mr. Wolf or someone will let us know, hey, that's been resolved and he's back in Fulton. We need to address this. Okay. Ms. Clark, anything else?
Yeah,
all right, thank you.
They just gave this man no bond. Said we gonna get you sent over to another jail to handle that first. Then bring you, man, please, because everybody know the county.
Do we have
bond?
We have an update?
You might have a hole over in another county, and Cobb County will come and get you. Got a hole.
I have the contact with the other two attorneys who should be within advice. That's Mr. Fazoli.
Okay.
Presently in 2B with Judge Brooks doing preliminary hearings. So he'll be up here as soon as he gets a free moment.
Okay, so he does want to go forward on his cases.
My understanding is that Mr. Fazoli said he is ready for Hutchison, Carson, and Drinkard.
Caslin, now Drinkard, okay, great.
And
does he have a client where he's saying sort of like your client, we're not doing it today?
Yes, that would be for Mighton and as well as Alvin Powell.
And you can't make this stuff up.
Okay, so Reuben Mighton, we will defer to another day. And you said Alvin Powell, number 5?
Yes.
Defer, got it. And then you said there was a third attorney.
Yes, one more. Jessica Jones, Attorney Jones, has Daryl Williams as position 1. She also she's not ready, but she would try to.
There's a young lady back there who says she represents Daryl Williams. That was the name. I still didn't get it. She was way in the back.
Okay, Mr. Williams hired prior to him.
Okay, and did Ms. Jones have anyone else, or that was it? So Hutchison is Cazzoli, and he'll be here. Kuykendall, we don't know. McCaslin is Cazzoli, and he'll be here. Alvin Powell, we're deferring. Drinkard is Cazzoli, and he'll be here. Mighton, we've taken care of. You're Roderick Powell. And then we don't know about Beatty, but that may also be the young lady.
Yes, I know the Beatty is hired by the council, that attorney's here.
Okay.
And I can also say that Kuykendall is a co-defendant of the castle, so she would be
a conflict defender.
I don't know if they got those.
Yeah, maybe not. So I'll at least let Ms. Kuykendall know we're not ignoring bond. We just, ma'am, are you ready to go on Daryl Williams? And did you say you also have Mr. Beatty? Yeah. No, just, you had Carl Washington. Got it. So you've been retained by Mr. Williams or his family?
I am doing this hearing pro bono.
Okay.
I filed a limited extra hearing for the purpose of bond.
Just for bond. Okay, got it. Thank you. What do you want to do? So we still don't have candidate. He's not up yet. Okay, so if we got Williams, why don't we knock that out? And then do we have, who else do we have left?
Well, Kendrick. I ain't heard him say that man's name yet.
So McCaslin will be able to do both those, just the lawyer's not here, so we should leave them up. That's it? Okay, then why don't we bring Daryl Williams out, at least make progress. Number 5. Number 8. Number 9. Yeah, but we don't do anything until someone reaches out. We're proactive.
What the hell is
And then number 3 is a contract.
man, all this here.
So, yeah, we can do that today. If she gets brought over, I'll let her know.
Kind of like
what
that's
the situation is.
What old school we got? What's in there for old school?
That's Cazzoli, and Cazzoli will be here. He'll be here.
Old school don't jump on somebody.
You bet.
Old school don't jump on somebody.
All right, Ms. Rivers, are you ready? Okay, this is 24 PI 008200, State versus Daryl Williams. Good morning, Mr. Williams.
How you doing?
I'm okay. I'm Judge McBurney. I don't think we've met before, but we are going to talk about bond in your case. That's all we're doing today, just bond. And as long as there are bond issues in your case before it's indicted, that'll be in front of me. Once it's indicted, it's going to be randomly assigned. Could be me, could be a different judge. We'll see what the state's doing with the indictment. I need your lawyer to announce her appearance so we get that on the record.
Well, all these cases ain't been indicted. They ain't been indicted.
And spell your name now that you're closer to a microphone.
They got They can deny your bond. They can deny your bond if it ain't been 90 days.
Iasello, Ms. Iasello, thank you for being here for purposes of bond. Mr. Abate, are you handling this? Okay. Mr. Williams, you're charged with murder. You were originally charged with aggravated assault. And Mr. Clark passed away, so that was upgraded to murder.
He ain't getting
and I'm going to hear from Ms. Iasello why you should get a bond and in what amount. Then I'm going to hear from Mr. Abate about what the state thinks about bond. Let me pause for 1 minute. Ms. Clark, you were going to give me a victim impact statement. But when we have another hearing on Mr.
What Fulton County got going on?
So, Ms. Iasello, when you're ready.
Oh, gee, call them a fresh one.
I think it's easier for Ms. Rivers to hear you if you do that. Thank you.
Why, please? Please, bond denied.
Good morning, Your Honor. Thank you for the opportunity to present this bond argument on behalf of Mr. Daryl Eric Williams, a man who stands before this court accused of a serious charge, murder. While the charge is significant, Mr. Williams is presumed innocent, and the purpose of bond is not to punish, but to ensure his appearance in court and protect the community. We respectfully submit that Mr. Williams is not a flight risk, is not a danger to the community, and is not a risk of committing new offenses or obstructing justice. Under Ayala, these 4 factors guide the court's decision on bond, and the facts of Mr. Williams' case support the granting of bond. In addition, I must bring the court's attention to Mr. Williams' significant and urgent medical concerns. Mr. Williams suffers from chronic kidney disease, is a kidney transplant recipient, is diabetic, and also suffers from neuropathy. These conditions require regular medical care, specialized medication, and monitoring that the Fulton County Jail is ill-equipped to provide. Denying him bond under these circumstances would expose him to substantial and unnecessary risk to his health. Lastly, it is critical for the court to know that Mr. Williams is the person who called 911 during the incident that led to his arrest. This act of seeking help does not align with the actions of someone trying to flee, evade, or obstruct justice. Due to a miscommunication with responding officers, Mr. Williams was charged. We are confident that as the facts unfold, the charges will be reconsidered, but in the meantime, we ask that the court grant him a bond so he can receive the medical care he urgently requires. The first Ayala factor asks whether Mr. Williams poses a risk of flight. The evidence clearly shows that he does not. Mr. Williams was the 911 caller and not a fleeing suspect. The most compelling evidence that Mr. Williams is not a flight risk is the fact that he is the person who called 911 and was not fleeing the scene, hiding, or attempting to avoid law enforcement. Instead, he actively sought help and remained present as officers arrived. As I stated, Mr. Williams' health condition makes it impossible for him to flee. He is a kidney transplant recipient and requires ongoing medical care, including strict medication schedules, metformin for his diabetes, and treatment for neuropathy. Any interruption to his medical regime could have catastrophic effects on his health. He has every reason to stay near his medical providers and avoid life-threatening risks of being on the run. Mr. Williams is deeply rooted in this community. He's the father of 4 children, 2 adult daughters, and 2 young boys. He volunteers with food distribution programs to give back to those who have less than him. His friends care for him so deeply that they reached out to me when they were unable to find him around Thanksgiving and subsequently located him on the inmate roster at the Fulton County Jail. I agreed to handle this hearing pro bono because I was moved by the love and concern of his friends who were desperate to help a man they described as thoughtful, generous, and kind. Mr. Williams has no history of failing to appear for court proceedings. He has shown compliance with all legal obligations and has no pattern of attempting to evade responsibility. The second Ayala factor asks whether Mr. Williams poses a danger to the community. Here, there's no credible evidence to support such a finding. Mr. Williams does not have a serious prior history of violence or any criminal history involving firearms or weapons. The court is not being asked to evaluate a person with a pattern of dangerous behavior. It's also worth noting that Mr. Williams is 61 years old and does not have a history of weapons charges. Mr. Williams' role as the person who called 911 is critical to this analysis. His actions show that he sought help, not harm. The fact that the charges rose from a miscommunication with responding officers should be carefully considered. If the court has concerns about community safety, Mr. Williams is willing to submit to restrictive bond conditions, including curfews or electronic monitoring and pretrial check-ins. As far as the third Ayala factor, risk of committing new offenses, Mr. Williams does not have a pattern of repeated offenses. His record shows that he has been a law-abiding member of the community. He does have a pending battery charge from July, but as that case unfolds, it will be clear that he was defending himself from attack. Mr. Williams' primary focus is his health. Managing kidney disease, diabetes, and neuropathy leaves little room for anything else. His medical condition creates a natural structure in his life that drastically reduces the likelihood of reoffending. If there's any doubt, like I said, he is willing to submit to restrictive bond conditions. And there's no indication that Mr. Williams would interfere with the administration of justice. He has no history of obstructing justice, tampering with witnesses, or evading legal obligations. And it bears repeating that he is the one who actively invited law enforcement to the scene and was not attempting to flee. And again, I would emphasize Mr. Williams' urgent and unique health needs, which the Fulton County Jail, frankly, does not have the capacity to address or provide the level of care that he requires. And therefore, I would suggest that denying bond in this case would prove to be life-threatening for Mr. Williams. We request a reasonable bond that is aligned with Mr. Williams' financial means. He is on a fixed income from disability and faces eviction soon based on the fact that he's been incarcerated for a month and has fallen behind on his rent during that time. I'd ask the court to consider a bond not to exceed $25,000. I recognize that the charge is very serious, but he does have very limited financial means, and we would be amenable to any restrictive conditions the court sees fit to impose. In conclusion, I would submit that the 4 Ayala factors weigh in favor of granting Mr. Williams a bond. He is not a flight risk. He is not a threat to the community. He has no risk of reoffending, and his medical needs create an urgent and compelling reason for his release. For these reasons, I respectfully ask that Mr. Williams be granted a bond. Thank you.
Well, I have one question, and then there may be follow-up from you after we hear from the state. Is it your understanding of the situation that Mr. Williams was on the outside allegedly shooting in, or he was on the inside allegedly shooting out, if you know anything about the situation?
So my understanding of the situation is that Mr. Williams was in his home and heard shots outside his house and called 911 from the inside of his residence.
Okay. All right, thank you.
Good morning, Judge.
Good morning.
The state would respectfully request you deny defense counsel's motion for bond for several reasons. The first being that the defendant does have 3 prior felony convictions, making him an A and C recidivist, in the sense that if convicted after trial, he'd be facing a mandatory life without the possibility of parole sentence. Furthermore, the state would submit to the court that the defendant is a risk of flight due to the strength of the case, in that Mr. Williams is seen on the ring camera waving a gun around after he shoots it through the door at the victim, who was inside of his home, who was struck in the face and ultimately dies.
So that was what I was asking Ms. Iasello about. Mr. Clark is the decedent.
Yes, Your Honor.
Mr. Clark is in his home, or he is in Mr. Williams's home?
Mr. Clark is in his home, and
Meaning Mr. Clark's home.
Mr. Clark's home, yes.
And what you say that the ring cam video would show is that Mr. Williams would be outside the door, not of Mr. Williams's home, but outside of Mr. Clark's home.
That is correct.
And shoots into Mr. Clark's home.
That is correct.
Okay.
And actually shoots through the door and strikes Mr. Clark on the left side of his head. Ultimately, police are called and medical attention is attempted, but about 20 days later, he does succumb to his injuries due to being shot in the head. So I would submit to the court that he is a threat or danger to people in the community in it, as he shot Mr. Clark through his own door, unarmed at the time, and posing no threat to the defendant, excuse me.
Ms. Iasello indicated that Mr. Williams was the one who called the police and that he stayed on scene. Is that your understanding of the facts?
He is one of 3 people who called the police. He is actually the 3rd individual who called the police. The first 2 described that Mr. Williams was outside of the doors of not only their apartments, it's a 4-unit apartment building or home. And he was—
Is Mr. Williams one of the 4 occupants?
That is correct, Your Honor.
Okay, so he's around his own space, may not have been his door, but it wasn't that he lived across town and came to this place.
Correct.
Okay.
Outside of their doors, screaming threats at all parties who were around and living in the apartment building. So 2 individuals called, 2 females called 911 indicating that, and that they saw Mr. Williams outside their doors and the door of Mr. Clark waving the firearm, and then heard a single shot. Mr. Williams did then call 911 and was incoherent, I guess is the best way to put it. He was under the influence of something would be what the state would submit to the court, and he indicated that someone had just shot his brother. And I can clearly state to the court that Mr. Clark is not Mr. Williams' brother. And he did remain on scene. Upon the officers arriving, he did admit to shooting Mr. Clark through the door. So I can agree with defense counsel as it relates to that. So based on all the factors, Your Honor, and all the totality of the circumstances, the state would submit to the court that at this time, Mr. Williams is not a good candidate for bond and should remain in the custody of the Fulton County Jail.
Do you have any information? I don't know that they'd be reaching out to you. I'll be doing some outreach about the jail's ability to tend to Mr. Williams's health needs.
I don't. I can obviously reach out to whoever needs to be reached out to. I neglected to inform the court as well. The incident that occurred that defense counsel had referenced that Mr. Williams was out on bond for. It was an assault from July of this year. It was actually an assault on the same victim.
Mr. Clark.
Yes, and there are eyewitnesses who watched Mr. Williams out of nowhere begin to attack Mr. Clark as he sat on the porch and was defenseless at that point as well.
All right, thank you. Ms. Iasello, I'll hear from you again. I forgot to ask Ms. Jackson from pretrial services about Mr. Williams's criminal history. It sounds like Ms. Jackson, Mr. Williams has some convictions. I'm curious how old they are, if they're from the 1990s or if they're from 2 years ago. What information do you have?
Okay, they're from the 90s, Your Honor. He has 18 cycles. The last arrest was July the 19th, 2000.
They're often, majority of them from the late 1990s. The most recent one is from 2002. So terrorist threats out of the Cap County.
Okay.
Ms. Nelson or Ms. Hansberry, can you call IT so we can figure out why we're not able to hear folks who have dialed in? It sounds like it's not just a probation issue. I mean, there's clearly something going on in the courtroom, but we weren't able to hear Ms. Jackson. Thank you.
Can you hear me now, Your Honor?
Iasello, I would like, with your client's permission, to be able to talk with the jail medical staff. They'll be more candid with me if Mr. Williams says, hey, you can talk to Judge McBurney about this. Yeah, that's me. This seems different, but because it's clear, like we see the little microphone is showing that it's receiving things, but it's not coming out of the podium. But you may be right. Oh, it was not working either. Okay, so they should swing by. Thank you. So.
Mr. Williams is fine with you.
Okay, and Mr. Williams, I'm not trying to pry into your personal medical situation, but it's important that you get the care you need regardless of these charges. And I need to balance whether that can happen while you're in custody or if you need to be out on bond for that. So that's helpful, and I will reach out to the doctor who manages the healthcare at the jail. Was there anything, Ms. Iasello, you wanted to add or respond to?
Your Honor, I've not had the opportunity to review the ring footage, so I can't speak to the accuracy of of counsel's characterization of that. But I would submit that Mr. Williams was obviously in his home. He did not flee the scene. He is committed to fighting these charges and clearing his name, and I do believe he is a good candidate for bond.
Okay. Your entry is for bond. Is it as long as we're going back and forth about bond, or it was for today? Okay, all right. Mr. Williams, I'm not going to set a bond at this point. I need to talk with the doctor at the jail to better understand how the jail might be able to or might not be able to support your health needs. In the interim, I guess, I'm fine requiring the state to get the ring camera footage to you, even though you won't necessarily be the lawyer long-term. It's certainly helpful. They're not obligated to do that, but I often ask when the state is particularly reliant on something in a bond hearing to get that to the other side.
I would appreciate that.
Okay, great. Mr. Abate, would you be able to get to Ms. Iasello the ring? Oh, he's gone. Mr. Rao, would you be able to get the ring camera footage? I don't mean right now, but just in the next few days, get that across to Ms. Iasello.
Absolutely.
Is he coming back?
You should.
Okay. Did he have to go down to 1C?
I believe so.
Okay. It's that kind of day. Yeah. So do you have any questions about what I said, Mr. Williams?
He wants to ask a question.
Okay, what's your question, sir?
I see. If we got jail, they're not gonna. I mean, I already know that because the day of telling my kidney, okay, she was saying that that blue thing showed that my kidneys were good, but I've been at a transplant, okay. All right, my brother gave me a kidney. And they just looking in that face for people, you know what I mean? They just gonna do that, yeah, for people like that.
Okay, well, that's what I'm gonna talk to them about. And are you on dialysis, or because you have a new kidney, you're not on dialysis?
See, I go back to the spag, so that just I gotta go back for every 3 months.
Okay,
To be put on, they call that, extra dollars, okay? Like, I don't build it like, people out like that, build like overnight.
okay.
Out,
Well, I'll talk with the doctor and then I will certainly let your lawyer and the prosecutor know, okay?
Okay.
You're welcome.
What time?
All right, so do we need to take a break so you can move people up and down, or do we have other people up to handle? Okay, we'll do that. Thank you. Mr. Rao, are you handling this or do we need Mr. Abate back? You're handling, okay. Let's get one thing up here on the screen. All right, Ms. Rivers, are you ready?
Yes.
Okay, this is 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick. I'm all right. How are you doing? I bet you could if you wanted to. I'm Judge McBurney, and we are going to work through bond in your two cases. You've got one case that's assigned to me in which you're charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these two cases?
Through the duration.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these two cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me when you're ready.
Yeah, I'm watching them too. I was gonna switch back and forth, but shoot, this will be over with.
Good morning, Your Honor.
Good morning.
Let's hear her.
And if you don't mind, I'm gonna condense both the cases into one argument.
That's fine.
Okay.
We mind.
I'm just gonna keep it short and sweet. As this honorable court, I'm pretty sure it knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to give a bond. This is a jail incident, Your Honor, and I come before you a lot, and it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're gonna get a jail case. It's almost inevitable, and especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened.
If he didn't do it, he wouldn't have been there.
He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to be given a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom, or?
No, he was in trial, but the co-defendants were.
Okay, so there was a prelim, not as to him personally and directly, because he was in 1C.
Yes, Judge.
But in 2B, one floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are gonna work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
I tell you about 20,000.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years. So it's not like there's a job at this firm where he was working for, hey, we held your spot for 2.5 years. But I trust you and he have discussed something about the structure that would be in place. And that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And as soon as he's released, I believe he's going to start back making music. And before this, I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later as he sat in the Fulton County jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
he would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record, just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these two cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so, while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot. It's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and I'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as, you can't go to those studios, because those studios are ones where we read about them and it's a great music making place, and the next day there's a dead guy in the parking lot. And it has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're gonna be working on getting a studio in wherever he resides, so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of it. Maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about, well, what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says, here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Yeah. Sound like he might be getting them.
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone who is not in court can hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great.
The service ain't even
okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from DCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you, having been indicted on 2 separate cases. Opposing counsel presented to the court. Aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant was alleged to have been the main perpetrator amongst 7 co-defendants who have also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Daryl Williams, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case, because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. it's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant Thomas's lawyers, is that not all, and they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case. Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the main perpetrator remained there.
Let me pause you for 1 second. IT thinks they fixed the situation. Let's try Officer Evans. Officer Evans, can you?
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Ms.
Yes, Your Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your view from a review, your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the Sheriff's Office had an opportunity to speak with Mr. Kendrick. And essentially there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both, but with respect to Mr. Kendrick, it's essentially he's saying, what else am I going to do? It's about respect. They're stealing my stuff. I got to do something. So I would disagree with the assertions that this is just a battery. And I think I'm more than happy to share the photographs with the court, and then the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015.
I wonder who got the warrant.
The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC, for which he was sentenced on February 22nd, 2017. And I do see at least a probation violation on 2020. There wasn't any further information as to why, whether it was a technical or substantive violation.
It might be what a whole.
Then on August 28th, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation of criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in the vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement in the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC 140116. And it does appear that he is on active probation for that particular case, having been sentenced to 15 years to serve 2 sentences, with the balance of the first 8 years on probation, with the remaining last 5 years.
Oh, they don't violate his probation.
In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022, and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents,
right, Kiki, this ain't good.
10
ain't no way this
are
good.
Allegations of violence, and 3 are allegations of possession of contraband. And those include the indicted cases before the court today, which the defense is seeking a bond hearing. And many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. And every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assaults. And so while I certainly understand everyone is talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond. We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for a management, frankly. I mean, just Bumpus needs to know what she and her client are up against. And I know that your office exercises discretion and doesn't indict every little scuffle that happens at the jail. Is it safe to assume that your office has filtered through that and we've got the 2 cases, the contraband and the assault? Or what's your sense? I know you're not committing the office, you're not in that unit, but you do have some managerial perspective.
From my understanding, Judge, there is one unindicted case that's been brought to our office. So I'm going to take a look at that and make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation, a bond hearing or a sentencing hearing. That is your best forecast, with maybe one exception.
That's correct.
He just talked this.
All right. Thank you. Thank you. Ms. Bumpus, want to give you the last word. I'm gonna not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that, because the last time that my client committed a crime was in 2015, 10 years ago. And well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case. So they're not 2 separate crimes.
Got it.
This 2015 is the federal case.
All right. So there just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not 2 separate acts. And me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. And it may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks, but that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as is par for poor Mr. Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband.
No way.
Was allegedly part of the assault. That's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted or it's dismissed, or I know that judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that warrant's out of the way. And then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases for which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
I got it.
And that the additional alleged acts in the jail, I mean, he has not been charged with those.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, and then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff, and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. Like, all right, and this time it was a cell phone. This time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao is going to look into that. And they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay. And we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes the bond moot in these 2 cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay. Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure. Good lawyer, she's going to explain it all to you, but there's a chance right now, not about the facts of your case. Don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these 2 cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured. So I can see if I'm comfortable that there's a set of conditions that would keep Mr. Kendrick safe and also keep him out of the kinds of things that he needs to stay out of until he resolves these 2 cases.
And Your Honor, how am I gonna, can someone email me about the probation? Or?
I will keep everyone in the loop.
Okay, thank you, Judge.
All right, Mr. Rao, anything else from the state?
Yeah.
All right, for those of you who were here for Mr. Kendrick, thank you for being here. I'm sorry you had to give up your phone. You'll get it back when you leave.
Hey, yeah, man. Y'all see this?
Yes, ma'am. Thank you for being here.
They just brought their man in there. They didn't say they were going to give him a bond or not. Well, clearly you're not getting a bond. Go handle the warrant. That ain't how this stuff works, y'all. You supposed to get his man a bond. He supposed to pay his bond and then go handle wherever his hole is at. You feel me? Because he can call his probation officer and say, look, lift this hole off of me. I got a bond.
I just need to know what what is remaining.
You got a hold. Can you lift this hold?
Excellent. Thank you, gentlemen.
Other than
Maybe
that,
we can.
a revocation hearing. So you might as well
She
go
is?
ahead and have a revocation
Okay.
hearing.
Do you want to,
That wasn't finna
would it
happen.
be helpful that the Miss Kuykendall, we can't handle today, but I could tell her that and then you guys can take her down. I'm assuming that's complicated to have her up here. Okay, why don't you just bring her right to the door?
Hey, let's go over to the other one, see what they got going on. Yeah, Caleb Bumper don't know what she doing, so she ain't even know the man had no damn warrant.
Let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion. None?
I gotta, let me run it back. Let me start back a little bit because I ain't see what happened with Miles.
What if I told you this was the last ad you would ever see? Still here?
You solemnly swear to affirm that the testimony about giving the matters pending before this court will be the truth, the whole truth, nothing but the truth, sir. Yes, sir. Hey, put your hand up. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask you more questions. Choose if you want. Irregularly that you have not taken today that would affect your ability to understand why you're here. And how old are you, sir? How far have you gone? And are you able to
also speak into the mic, please?
26 and got a bachelor's degree? And so are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, of which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm and the commission of felony. You understand you're currently charged or indicted with those counts. Yes. And you understand that you have the right to plead either not guilty, guilty or not guilty to these charges. And if you pled not guilty or remain silent, you may receive a jury trial. Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to? Yes. And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years? Yes. And do you have any questions as it relates to that count, the single count you'll be pleading guilty to? No. And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, so the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge. Yes. Do you have any questions about that? No.
Is he just pleading to count 1 and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts? Yes. And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else? Yes. Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir? Yes. Do you also understand that by pleading guilty, you're giving up or waiving the following rights? The right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you're unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand by taking a guilty plea here today that you're waiving or giving up all of those rights? Yes. And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today? No. And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that is in your best interest to do so? Yes. And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial? Yes. Okay. And how do you plead to count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572? Guilty on the Alford. And Mr. Farley, is this Alford guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to? Yes. And you understand that you may have a limited right to appeal this guilty plea conviction? Yes. Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea? Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he.
Yes, ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraint that you have to file under those areas of the law. Yes. Okay. Do you have any questions about that? No. Okay.
All right, and your attorney, Mr. Menendez, will represent you until 30 days from now or the last day of this term of court, whichever is later. And he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am. And just for the record, it's clear I just provided to Ms. Persefield the indictment, which was signed by all parties as it relates to the defendant's guilty plea to count one conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. The recommendation as it relates to, or the joint recommendation that the parties would make to the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but It's also my understanding he qualifies for the first offender or treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either. And the recommendation would be 5 years to be served on probation.
All right. Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right. And have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon. Understand? All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alfred. Do you understand that?
Yes, ma'am.
Right. Mr. Monetis, is there anything else that the defense would like to place on the record?
Yes, Judge, I just want to add a little bit of nuance to the plea. The court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing, his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alfred. In 2019, him and a friend created a clothing item, a hat, that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area: his creativity, intelligence, tenacity, his bravery, and taking things this far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. And he just doesn't want to go to trial. And that's why I think Alfred is a textbook case for this type of situation. And so if the court has any questions, we just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alford and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
They didn't have any real special conditions, obviously, other than follow the law.
Okay. All right. Well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No, ma'am.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you'd be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up and that you are following the law. All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If he would wait, Ms. Jolly is on the way.
All right. Mr. Menadas, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, Your Honor.
All right. Yeah, that'll be fine. And after you meet with her, then you are excused. Thank you. All right. Are there any other guilty pleas that are going to be tendered today? All right. So what I would like to do is, and we can just start up here with Mr. Mender, and I'd like the state to put on the record what the plea offer is.
With Ultra Mobile, home is never too far away. Whether you want to connect to loved ones here or abroad, Ultra provides unlimited nationwide talk, global text, and unlimited talk to 90+ international destinations, all on the T-Mobile 5G network. And for a limited time, get 20% off our 5 GB plan and pay only $16 a month. Visit ultramobile.com to start saving today.
My biggest concern when I was thinking of getting Botox Cosmetic was
losing my expression. I wanted to stay Javi and stay me.
the doctor did great at explaining that the treatment plan for me was what I needed.
So I got treated on my forehead.
My crow's feet and my frown lines. I am so happy with the results.
My results are subtle,
I'm still myself.
just with fewer lines.
Talk to your doctor about Botox Cosmetic and whether it's right for you. The effects of Botox Cosmetic may spread hours to weeks after injection, causing serious symptoms. Learn more at BotoxCosmetic.com.
Or could be exactly what one of the recommendations is, but as long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, ma'am.
Okay. All right. So, Mr. Mender.
My
you
bad.
have this
My
case
bad. I had to
pending,
walk out
and
for a
you have
second. I'm
another
back though.
case pending as well. Is that right?
And Your Honor, so we were going to respectfully request a hold our announcement and to have an opportunity to approach the court at the bench and whenever convenient before we move forward.
All right. So I will come back to y'all. So, Mr. Garlington and Mr. Mondelli and Mr. Abadi, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor, on December 9th of 2024, an offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering guilty plea. The recommendation from the state was for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it be reduced to the lesser included offense of voluntary manslaughter, and plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 all parolable time.
All right, and as a part of that plea offer, you all were gonna null cross 40, 42, 43, and 51, is that right?
That's correct, sir.
All right. All right, and Mr. Mondelli, you discussed with your client the potential sentences that could be faced.
Okay, y'all, I'm not gonna talk long. I'm gonna go ahead and
goes to
clip.
trial and is
He is
convicted
back
of
at
all
the
counts.
courthouse. Allegedly, they got his sister.
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still
Oh, we got to find out what happened with Shannon.
into account and fairly often probably sentence in accord with that, but that is certainly not a guarantee. So, Mr. Abadi, would you be able to put on the record
I forgot who Shannon got, but his ain't. They saying they don't think they're gonna let no cameras in the courtroom on his.
Plus,
He probably finna go in there and tell. He don't want no cameras in there. Finna take that
just
plea.
say another thing as well. I know that there was a not guilty or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. The, I don't know, state's sort of story, theory, if you will, might or might not be the same. And the ultimate outcome might or might not be the same. And I'll tell you, and I'm sure that all of your attorneys have told y'all that acquittals with the jury are a rarity. So just keep that in mind. It does not mean that the same thing would happen to you. Y'all, you know, we've got a different prosecutor at the table who I hope would stay through the trial of the case. And it just is probably going to look a lot different. There's also a different judge at the beginning. So keep that in mind, but I understand that for now y'all will be rejecting that offer.
They might can.
All
They,
right. So we've got Mr. Eppinger, and I know Mr. Eppinger still has a motion pending. I will tell, and Mr. Johnson, you should now have all of the transcripts from the main witnesses who testified around the 2 attempted murder counts at trial. And if we are not having a plea today, I'm obviously we're not going to have that hearing today, but I would be interested in going ahead and getting that scheduled. And I will say that I have heard the testimony as it was presented at the last trial, and I have seen the videos. I don't know what might be presented at the immunity motion, but I'm fairly certain that those 2 videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just understood. Mr. Eppinger, you understand that as well? Okay. All right. So, Mr. Body, can you put on the record what the offer tendered to Mr. Eppinger was, please?
Yes, Your Honor. The state offer as it relates to Mr. Eppinger was a global sentence of life imprisonment as it relates to the armed robbery and everything else to run concurrent on this indictment, but that sentence run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Eppinger is facing a minimum of a life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Eppinger is facing approximately 15 different felony charges on this indictment. Is that right?
That is correct, Your Honor.
All right. All right. And if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Eppinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Eppinger?
Yes, Your Honor.
You understand that, Mr. Eppinger? Okay. All right. And was there something else you wanted to say?
No, I just based on the circumstances, I came to the podium.
Okay.
But given the state's offer, Your Honor, at this time we would reject that offer based on our view and our view of the evidence in this particular case.
All right.
So yes, we would reject that matter and like to proceed to trial.
All right. And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates, and I'll talk with y'all first about in the immunity hearing date as well. All right, thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right, not December though, not that soon. Okay, so have we covered everybody other than Mr. Minder at this point? Yes. All right, so let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
Statement of no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
is the complaining officer, Your Honor. That would probably be
Okay. Well, there are 2 officers who got shot.
Well, actually, there's only one who got shot. There's
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
No, Your Honor.
I didn't think so.
Oh.
Okay.
Both, but the other witness is not.
Hold on. Shannon took the plea. What did he get? What did he take? Oh, that's why Matt Shaw was all in the courtroom a minute ago. What going on, Miss Cherie? What going on? How everybody doing? Hold on. Look. Okay, so Shannon went on and took the plea, so he probably finna get out. Yak got it. His them warrants came from when he caught them charges. Oh no, she just said what she said. Now, how she said it was the federal probation was supposed to override the state probation. So I'm assuming when he got locked up in 2022, but she said something about 2020. But whatever he did, he caught a new charge and they violated his probation. Now it seemed like they would have knew that come up 1919. If you on probation, you already know they finna put a hold on you. You already know they finna do that. Now I done seen situations where I have been locked up for a minute. And the time I paid my bond, my probation officer put a hold on me. I'm talking about the time I paid my bond, I thought I was finna get out. They was like, oh, you gotta go to Clayton County. I was like, dang. And I'm talking about I had been sitting there for like 3 months and nothing had came up or nothing. But the time I posted my bond, they put a hold on me. So I don't know how long he had the hold. All we got to do is find out where the warrant say. The warrant gonna tell them where they were. That they took the warrant out. But see, that's just more stuff that folks be caught up in. And I tell people all the time, you don't never know. People know what they be caught up in. You know why these people try to hit you up and up. You know why you got these charges on you. You know people know exactly why they in the situations that they be in. And that man know exactly why he in that situation. Okay? He know he got their probation stuff going on. He know he got these one going on. Caleb Bunker know it, you know what I'm saying? I told y'all this, and now y'all can take how y'all want to take. I told y'all I ain't never seen her get nobody up on. Me personally. And it ain't changed today. She, man, still ain't got a bond. They told this man everything but bond. You got this, you got that. Warren over here, go handle this. If you do this, we'll speed it along. Oh, all this. Man said, he told the man out the real, I can't even make a decision today. Ain't that what we here for? I mean, we here today for you to make a decision, ain't it? Man told bro off the real, I can't make a decision today because I got to think about it. Hey, you got to think I don't think nobody went in there got a bond, did they? Welcome to Fulton County. That is not abnormal for people to come back from court and ain't nobody get no bond. It ain't that. But you know, you got to look at the charges they got. Dude had an M charge. That man about 80 years old had an M on him. But you know. Okay, but yeah, so you say he got named, got his plea worked out. Okay. And that's what I really want to do. I want to goddamn take a look around and see what's going on. But yeah, one life we've been going for a little minute. Let me goddamn get situated, man, and look around. I'm gonna see what I can find on Shannon's plea bargain and see what I can come up with. If y'all got something, man, y'all send it to me so I can check it out. But I'm finna check and see what they got going on with Shannon's stuff. I want to look more into this Yak warrant. Find out what that's about, right? I'm pretty sure, like she said, about that probation situation. Now, that can be easy. He can call the probation officer and say, look, can you take this hold off of me? You feel me? You know, worst case, all he got to do is have a revocation hearing. He can have that. And it's crazy that he ain't already had the revocation hearing, but I guess due to the nature of the charges or even when they took out the warrant that they just got dang waiting. But you normally supposed to have your probation violation hearing within 7 to 14 business days. You feel me? You normally go ahead and knock that out. Me, I done been lucky, blessed, and stuff like that. Cause a lot of time, by the time I be done got locked up or something, my probation be done ended, or it be running out before I go to court. Now I done been to court and been violated. It'd be like anywhere from 2 days, 5 days, I don't know, to some months, just depending on how many violations you got and what you did. But yeah, so I'm tap in with y'all in a minute, One Life. Let me go goddamn do some research, man, and see what kind of information I can bring y'all. I appreciate everybody for pulling up, man. Shouts out to Mimi again for the new One Life member, man. She joined One Life today. I really appreciate that. But shouts out to everybody else as well, man. Bougie, Miss Reed, Kiki. Let's see, Payne. Shouts out to Payne, man. That boy Payne is full. Shouts out to Lee. Shouts out to everybody, man. Twyla, Dana, thank y'all so much for pulling up, man. Joker and everybody, man, I appreciate it. And I will catch y'all in a minute.